Thanks, Mike. Welcome and thank you for joining Seyfarth's webinar, Back to the Future or the Past, What 22 Has in Store for Labor and Employment Laws. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and it is required for CLE credit. Copies of the webinar recording and materials, as well as the CLE verification form, will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Erin Foley. Erin, you may begin.
Good morning, everyone. Thank you. Julianne, can you go to our presenter slide, please? Thank you all for joining us this morning. I am super excited to turn this over shortly to my amazing colleagues here in the Chicago office. This is hopefully the last virtual breakfast briefing that we'll be able to do this year. Well, it's the last one we're going to do this year, let's put it that way. Hopefully, when we get into Q1 of 2022, we'll be live back in the office, but, you know, things have been a little bit strange this year, which is part of the reason why we're doing this particular presentation. So I would like to just remind, Julianne just said it, I'll remind everyone, please feel free to use the Q&A in the corner. We're going to be monitoring it during the course of the program. We'll try and get questions answered at the end because we want to make sure that each of our speakers has an opportunity to tell you what their topics of interest for you today. And thank you all very much for joining us. I'm really pleased that we've got such great attendance today. So with that, I'm going to kick it over to my colleague, Adam Young. Adam's part of our environmental and OSHA group here in Chicago, as the other panelists will be able to come in just a few minutes, and then we look forward to your questions. Thank you all very much for joining us. I'm going to go off camera. You don't need to see me. Enjoy the program, everybody. Take it, Adam.
All righty, thank you, Erin. If we go to the next slide, please. Good morning, everyone. My name is Adam Young, and as Erin said, I'm a partner in Seyfarth's Chicago office. I specialize in OSHA and workplace safety. If you go on to the next slide, please. We're going to be talking about the OSHA COVID-19 Emergency Temporary Standard, but I want to get you first an overview. The Biden administration has been very clear that their primary domestic goal in the election and then as an administration is to reduce the severity of the ongoing COVID-19 pandemic. And one of the solutions that they came up with to how to do that is a mass vaccination plan through the FDA-approved options. And members of the administration have been pretty open that the intent is to use every public policy tool they have to achieve that goal and public health goals with regard to vaccination and the pandemic. They have a range of tools in the public sector, and then there's three main efforts at vaccination mandates that they've pursued in the private sector. They're really breaking new ground in a lot of these areas. There's not a lot of precedent for vaccination mandates being done through OSHA, for instance. So I think part of the idea was that employers will be trying to comply with these, employees will be getting vaccinated, and even if they're thrown out by the courts down the line, maybe they'll be substantially effective in increasing the numbers of vaccinations in the near term. So these three efforts were the federal contractor mandate, which applies to employers of any size who have federal contracts or are subcontractors to a federal contractor. And the due dates for vaccination had been pushed back to January 18, 2022, currently in litigation and has been enjoined. We'll talk about that in a second. The second one on the bottom here is the Center for Medicare and Medicaid Services, or CMS mandate, which applies to healthcare. If employers are receiving funds from that agency. So this requires vaccination for employees working in hospitals. For now, the OSHA vaccination and testing ETS that I'll largely be talking about does not apply to hospital employees because a lot of healthcare folks are covered by a special OSHA healthcare standard. That healthcare standard is scheduled to sunset in 2 weeks, which would make hospitals covered by the OSHA standard as well, and we'll talk about that in a little more detail. And then finally, in the middle, the private business mandate, or federal OSHA, issued an emergency temporary standard. This applies to employers with 100 or more employees. Next slide, please. each of these efforts is under attack in federal court by Republican Attorney General and a variety of other litigants. The federal contractor mandate has been enjoined on a nationwide basis. It's currently being litigated. The CMS mandate has been enjoined on a nationwide basis, again, by a federal district court, and that's going to be litigated likely up at the Supreme Court. And then finally, OSHA's ETS was stayed by the Fifth Circuit. And then because 10 different suits have been filed around the country, a multi-district litigation panel assigned that case to the Sixth Circuit in Cincinnati, who's hearing the case. Currently, the government has moved to dissolve the Fifth Circuit stay, and the last briefing date is tomorrow for that. So the regulations are currently stayed by the Fifth Circuit. However, that stay could be dissolved very soon. It could be dissolved as early as tomorrow when briefs are submitted. The Sixth Circuit could intervene itself and say, look, this stay is improper. This regulation should be in effect going forward. If we go on to the next slide. So even though that OSHA ETS is stayed, most of our clients are moving forward as if those rules are going to be in place. That they're going to have testing in place, they're going to have vaccination in place, whatever those requirements are that I'll talk about in a second. We think it's possible that the Sixth Circuit will agree with the Fifth Circuit and throw out the ETS. You know, maybe % chance that that'll happen. And the reason why is OSHA has to prove to have an emergency temporary standard, that there's a grave danger and the standard's necessary. You know, OSHA has considered and rejected having an ETS for general industry and for areas outside of healthcare several times over the last 20 months or so, which would be good evidence that it's not really necessary to protect employees because OSHA made that determination several times. But we foresee reasonable arguments both ways. It could come out either way from the Sixth Circuit. It could come out either way for the Supreme Court. So the ETS, if it's good, it'll be good for 6 months. And the 21 state plans like California, Indiana, Washington State, Michigan, they'll all be required to have their own ETS within 30 days of the federal ETS being effective. If we go to the next slide, please. All right, so the ETS applies to employers with 100 or more employees, and that's counted on a nationwide basis. 100 employees at any time when that ETS is in effect, then that ETS will apply to you. You only count employers' own employees, not staffing agency employees, not temps who are out there. However, if you have several different companies under around the United States with different federal tax ID numbers, it may be that you have certain entities that don't qualify for the 100 employee threshold, and OSHA would cordon off, and it wouldn't be necessary to have that compliance with the ETS at those work sites. It doesn't cover work sites that are covered by the federal contractor mandate, and it doesn't cover work sites that are covered by the healthcare ETS, and those are hospitals mostly. And those regulations are scheduled to sunset in 2 weeks on December 18th, so it would be that if the federal government removes the stay, the ETS comes into effect, it will apply to hospitals as early as December 19th. All right, if we go on to the next slide, please. All right, so these were the requirements that were due on December 6th. The ETS has stayed. The December 6th date was illusory, but these are the components of what's in this regulation. The regulation requires an employer to have a vaccination policy, and that can be either what's called a hard mandate or a soft mandate. So you could require that everyone get vaccinated with no testing option except for the folks with a disability or religious exemptions. Or you could try the soft mandate under this regulation, which is individuals who don't want to get vaccinated can opt out and they can go the testing route. And that's at least weekly surveillance testing. It could be antigen testing. But that's a permissibility under this ETS, not the case with the federal contractor mandate, not the case with CMS. They don't let employers have that, I don't want to get vaccinated, I'm going to test option in there. ETS requires that you have vaccination policy and notify employees of COVID-19 diagnoses. You medically remove employees who receive a positive COVID-19 test. And that you train employees with regard to the ETS, and of course with regard to the efficacy of vaccination and the benefits of vaccination. That's what OSHA wants and the Biden administration wants employers talking about. is encouraging folks to get vaccinated. If we go on to the next slide, support for vaccination. Employees are required to be provided 4 hours of leave each time they need to go get a vaccine, and that would include both doses of the Pfizer or the Moderna vaccine. Paid time for obtaining that vaccine, paid sick leave if the employees have adverse reactions. While we're reading in the news now with the Omicron variant that there's a lot of recommendations from Pfizer, from Moderna about whether boosters are needed. Boosters are not incorporated into this regulation. They're not incorporated into the definition of a fully vaccinated individual. It's just having both doses and being 14 days out from getting the doses that are required. So not something that's required, not something that's required to be paid or tracked under the regulation as it stands now. What's difficult for a lot of our clients is getting a vaccination roster together. If you haven't been tracking vaccination status, you haven't been doing vaccine verification, it may be quite an effort to determine everyone who's vaccinated, not fully vaccinated, unvaccinated at your work site. So that's a big effort that a lot of our employers have been moving forward to do. I would say all of our clients have been preparing that roster, because if the January 4th date, the stays pulled down in December, and the January 4th date that we'll talk about in a second comes back into effect, it's very difficult to put together a vaccination status roster for an entire modern company overnight. And then finally, there's a masking requirement. The individuals who are unvaccinated are going to be required to mask when indoors. If we go on to the next slide, please. So these were the January 4th requirements. Pretty much everything had to be done ahead of time, and then the folks who weren't vaccinated and the employer had adopted the soft mandate, or we're going to let individuals continue to be unvaccinated, or there's other individuals who are unvaccinated for other reasons, such as disability or religious exemptions. Those folks are required to get weekly surveillance testing, and that can be antigen testing, but it can't be both self-administered and self-read. So you can't just have an employee say, "Oh, I tested myself, and here's my proof," or "Here, I'm going to sign this attestation." The regulation talks about proctoring, having a manager there while people are doing the test to ensure that they actually insert the swab in their nose and put in the median correctly. Testing can be unpaid. There's no requirement that employers pay for testing in the OSHA ETS. We have prepared a comprehensive chart of state requirements. Some states require employers to pay for things like COVID-19 testing. And we've also prepared a chart on testing time, what's required in terms of the time spent testing. And we're happy to provide those resources to anyone if you want to email us. All right, if we want to go on to the next slide. All right, well, thank you very much. That's the update on the OSHA ETS. I'd add, if the OSHA ETS is thrown out by the courts, there still is a requirement under OSHA's General Duty Clause to protect employees from recognized hazards in the workplace. And during a global pandemic, that includes COVID-19. So a lot of our clients have gotten General Duty Clause citations related to COVID-19. We encourage folks, plan as if, the COVID-19 ETS is coming into effect, because it absolutely still could. And it's very onerous and difficult to do that compliance. And then also, you're still required to have those precautions and protocols in place to protect employees, to make sure that you don't have OSHA liability and you don't have a risk of transmission of COVID at your workplace, or minimize that risk to the extent you can. All right, I'm going to turn things over to Tom, I believe, who's going to be talking about the NLRB. Thank you very much.
All right, thanks, Adam. Good morning, everybody. I'm Tom Posey, and I'm one of the partners here in our labor relations group. So to start out, I know a lot of you were here with us last year, and so at that time, as we were telling you what to expect for 2021, we told you about what we thought we would see from the Biden Labor Board, from the NLRB, what to expect on the labor front in general. This what we'd see: organizing efforts, a very labor-friendly climate, that it would be very management unfriendly. We had predicted for 2021, but none of that happened, and everything's fine. So thanks. That's all I have to say. No, unfortunately, that's not the case. There's been a lot of activity this last year, and a lot of it's been along the lines of what we were predicting a year ago. So if we go to the next slide, please. There's three areas we're going to talk about briefly here. The first is what we've seen at the NLRB and what we think we're going to see coming forward next year. Also, a little bit about what we've seen on the union organizing front and how the pandemic has impacted that. And then lastly, talking a little bit about the vaccine mandates, which you're going to hear a lot about this morning, and how that relates to your bargaining obligations with any unionized employees that you have in any of your locations. Next slide, please. So starting out with the NLRB first, and I promise we won't go into great detail on the NLRB process, but there's really three areas here where employers need to have some concern or understand how things work at the NLRB. So first, the NLRB is going to engage in rulemaking efforts. Now, this is going to be more rare, and so we're not going to really touch on that this morning. The other two issues, or areas rather, that we want to talk about a little bit are case decisions that we see from the NLRB and the general counsel memos. So on the case side, it's unfair labor practice charges and representation cases, so representation elections. And then the general counsel memos, that's any guidance from the general counsel of the NLRB on interpreting and applying both the law itself, the act, and some of the board decisions. And more importantly, the directives that then are made to the staff around the country and the regional offices based on those. So let's start with that general counsel piece and talk about that for a minute. We go to the next slide, please. So Jennifer Abruzzo is the general counsel of the NLRB who was sworn in last summer. Now, if you look, the first bullet here is important, and it's frankly not surprising, but she's the former special counsel for strategic initiatives for the Communication Workers of America. So she's coming from a labor background, not a management background, and that's obviously going to affect what the lens is that she looks at everything through. Now, she's going to be with us for a while. She has a 4-year term, and this the last bullet here is a quote that I think is representative of both what we could expect from her and what we've seen from her so far. And the underlying parts here are really what we've seen across the board, I think, over the course of most of this year from the NLRB, both at the regional level and nationally. There's been really vigorous enforcement of the National Labor Relations Act. Now, where that's come from in large part is this view that there's a need to bring equity to the process. Now, certainly as a management labor attorney, I didn't feel that there was an inequitable process there to begin with. But there is a view that's coming down from the top all the way up to the president that, listen, we think this needs to be balanced differently than it is and to be more really labor friendly than it has been over the last few years. Now that some of that, the focus for that has been through the pandemic, and as probably you're feeling just about everything over the last year or two has been tied into the pandemic, but really I think that's made it even easier to take this even further in a lot of ways with what the NLRB's been doing over the last 6 to 12 months. Go to the next slide, please. And along those lines, let's talk about some of the general counsel memos that have come out just over the course of a couple months. So Jennifer Abruzzo was sworn in July. In August and September, all the decisions on this slide, or the memos rather on this slide here, all came out in pretty rapid fire, and these are all pretty significant. The first one about mandatory submissions to advice, the most important thing to know here, which is again something I think all of you probably expected, is that any areas where the Trump board had changed precedent, shifted things to a more management friendly interpretation or application of the act, the advice from the general counsel's office is to reconsider those cases, to go back and say, wait a minute, should we open those back up and see if those went the right way? Now, there's other general initiatives, and we'll talk about a couple of these where she has instructed people to carefully examine different areas. The first of those was the Section 10J or injunction proceedings. So this is pursuing injunctive relief through the National Labor Relations Act. Now, this is generally relatively rare for this to be pursued. One of the things that the regional offices have been told is that they should use this a lot more than they have been. And so far, even in the last couple of months, we've seen more of that. We've seen more requests for that. Now, there hasn't been a lot of actual injunctive relief applied yet that we've seen, but there's certainly been more attempts to get that or more pursuit of that than there has been in the past, certainly the past few years. Now, another piece is seeking full remedies here. And what that means is when an unfair labor practice charge is filed, very often what the regional offices will do is during the investigation, come to the employer and say, well, we think there is some basis for this charge that was filed. So rather than continuing down the rest of the investigation path, filing a complaint, actually litigating this, we want to see if there's a way to resolve this, because if not, we're going to be pursuing the full remedies available. Now, what that means here is two things. First, that there's a shift towards trying to get more under the act. There's the biggest push here is to have more fines and penalties for employers that aren't there now. And the second one goes into what's going to happen if you settle your case, which is the second to last bullet here of seeking full remedies in settlement agreements. Now, up until this year, or at least over the last several years, it's been easier to settle an unfair labor practice charge if the other side is agreeable to doing that through a private or a non-board settlement. But the new challenge that we have here is the regional offices are saying, well, we're not going to allow you, the parties, if the employer and the union both say, all right, we've decided to settle this case under the following terms, whatever those are. The regional offices are saying, well, wait a minute, no, we want the employer to be on the hook for even more than that. We want to see exactly how much they're going to be paying out, even if the union has said, we're not seeking any sort of economic relief here. We don't think there should be a monetary payment, or we're not demanding some monetary payment to employees in connection with this settlement. The regional offices are stepping in and saying, well, we don't care if you're asking for that as the charging party. We're telling you that we won't let you settle this until we've run the numbers on it and decided that the employer has paid out enough to the employees to make this a fair settlement. Now, that's something that we certainly haven't seen much of in the past, and that's been becoming the norm over the last 5 or 6 months. Now, if we can go to the next slide, please. Related to these settlement agreements, something else that you may have heard about over the last few months is a push to get apology letters in connection with settlements. Now, we've started seeing these actually showing up in our cases. So this, if you take a moment and just read the one that's up here, this is something that was proposed by one of the regional offices in one of the unfair labor practice charges that's pending. The regional office is asking the employer to post this apology that essentially says, dear employees, we're very sorry for our egregious and disrespectful violations of the law. We apologize for our unfounded and unsubstantiated activities, and we're regretful we behaved this way, and we're so unprofessional, and we hope you'll accept this apology. Now, we don't have a video where I can see all of you, but I would assume there's some surprised faces going around the participants here if you weren't aware that this is something that the regional offices are pursuing right now. Now, what we haven't had yet, or at least I haven't experienced, is a case where the regional office has refused to let a settlement go through without one of these apologies. And some of the labor side, even some of the union representatives, at least off the record, have told us, wow, that's pretty crazy. I doubt you guys will agree to post one of those. So even they understand that this is pretty far reaching, but this is, we think, going to be the norm going forward. And this is not, unfortunately, the first one of these example settlement agreement suggestions that we've seen. So let's change gears a little bit and go to the next slide, please. We also want to talk about union organizing a little bit. So separate from what we're seeing at the NLRB, what are the unions doing what has been going on with organizing efforts over the last year and what do we expect to see going forward. Now, organizing efforts at non-union facilities, really we've seen targeted in 3 different areas based on either your industry, the specific employer, or what region of the country you're in. From an industry perspective, we've seen in the hospitality and the warehousing and distribution industries, definitely an uptick in organizing efforts, mostly focused on, or largely I should say, focused on pandemic-related issues. So in both of those industries, in the hospitality and the warehouse and distribution side, there's been a big push with employees to say, okay, as you're coming back from the pandemic, you need us to come in and represent you so that you're being treated fairly, so that whether there's a vaccine mandate, that we can help you with that with your employer. If you're not being called back to work, well, you should have us come in and represent you because we're going to get you all your jobs back. If you've been called back and you don't like the fact that you maybe didn't get some sort of payout before you were laid off, or get some sort of stipend from your employer during the pandemic, well, we're going to come in and try and get you one of those. So there's just about everything on organizing seems to be, like probably just about everything we're all experiencing now, pointing back to the pandemic or tied into it somehow as the basis for what they're doing. Now, the second piece is specific employers have been targeted. Obviously, this is mostly national, large-scale employers. Unfortunately, some of you on this call this morning are aware of that because you're some of the folks that have been targeted here. But there's been, from the corporate campaign side, some very intensive efforts against a few specific large employers to say, okay, let's get out as much as we can in the media and drum up public support for the fact that this particular company needs to be unionized. And if it's not, it's unfair. And so that's been another difficulty that some of you have faced this last year. From a regional perspective, this one isn't surprising that a lot of this has been in major cities, but I think 3 or 4 specifically we wanted to call out. In California, we've seen a lot of organizing efforts related to the pandemic issues. In Chicago, in the hospitality industry specifically, that Unite Here has been pushing pretty hard and working at a lot of hotels, even where they hadn't gotten much traction or headway over the course of 5, 10, 15 years of occasionally making those efforts at different hotels, are now starting to get some more traction with those. And then on the East Coast, especially in the Southeast, we've seen some more organizing especially in the warehouse and distribution side of, again, pandemic-related focuses here. Now that, with the pandemic piece, the vaccines and the vaccine mandates are a big piece of that, but to the union's credit and to the management side's difficulty, they've actually been using the vaccines, whether you're for or against, that's still being pointed to as a basis that you should bring in the union. So we have seen the same unions, in one instance, even the same local in different areas, saying, is your employer requiring you to get a vaccination? Well, you should bring us in to represent because we can help to slow that down. And then the same local in a different area is saying, well, is your employer not doing enough to make sure all your coworkers are vaccinated so that you're safe? Bring us in so we can help you to do that. So they're really using this any way they can to push those organizing efforts forward. So one last piece, and if you go to the next slide, please, that we want to talk about briefly is the vaccine mandates and bargaining with your unions. Now, one of the biggest questions we've seen over the last year is, do we have a legal obligation to bargain over requiring employees to be vaccinated and how we're going to handle that? Well, we don't necessarily have an obligation to bargain over the decision to do that, our decision to impose that requirement. What you absolutely have a legal obligation to do, though, is to bargain over the effects or the impact of both a government vaccine mandate that you're choosing to follow, or if you on your own have put in policies that say, whether there's a federal or state or local mandate or not, we are requiring you to either get vaccinated or be tested regularly. You absolutely have to bargain over the effects of that with your union. Now, in those effects bargaining sessions, what we've seen the most focus on there has been either on the amount of time that you're going to allow an employee to get vaccinated if they're not already. And from the union side, there's been a big push for incentives to do that. Monetary incentives either to get vaccinated in the first place or staffing incentives to say, well, if you're either the government mandates or your own requirement is about to hit a cutoff or a deadline where your employees, your staffing may go down because some of your employees are no longer able to work because they're not vaccinated, the union is pushing for some sort of incentive for the rest of the employees that if I pick up any extra shifts, I should get double time for doing that, whether I've hit overtime or not. So that's what you can expect to see if you haven't already in the effects bargaining you're doing with your union. So you should be prepared to address those issues, primarily the amount of time to get vaccinated and what monetary incentives, if any, you're going to be willing to provide for getting the vaccine or for staffing issues that come up related to that. Now, I know we went through a lot of that quickly, but we just wanted to give you a quick overview of what we've seen on the labor front in general in each of those areas. So if you do have any specific questions, please put those in the chat or we'll have some time at the end to take questions as well. So with that, I'm going to hand it over to Kyla, who's going to talk a little bit about what we've seen from handbook trends and developments and what to watch for next year. Thanks.
Good morning, everyone. My name's Kyla. I'm an associate here in the Chicago office. And today we're going to be talking about handbook trends that we've seen in 2021 and what to watch for in 2022. Next slide. So first, I want to talk about what is driving some of these trends. There are four main areas. The first would be a change in the administration. As you've already heard from Tom and Adam, that can have pretty significant effects on the law and, of course, then on policies that you place in your handbooks as well. So now that we have a Democratic administration, we're seeing more activity from the EEOC, the NLRB, the DOL, and then also initiatives like paid family leave on the federal level, which would, of course, cause changes to your handbook. We're also seeing a lot of social and political issues come into play here, and more frequently than ever, we're now seeing those spill into the workplace. And in turn, that's going to affect the stances that employers are taking. For example, you all know the Me Too movement increased the focus on gender harassment and discrimination, and because of that, a lot of state legislatures updated laws, and then, we all had to go and update our handbooks and our sexual harassment policies to make them in compliance with those various state laws. So these things are constantly changing. The third piece would be obviously changes to the law are going to affect your policies, and we'll touch on that a bit at the end. And then how we work. So the effect of this pandemic has obviously had a huge change in where and how we are working on a day-to-day basis. Next slide. So some key trends that we're seeing, we're going to start by talking about diversity, equity, inclusion, and belonging. And then ESG is actually something that I'm going to have Amina and Jen speak to at the end of the presentation, but that's also a huge driver of some of these trends. Then, of course, remote and hybrid work, sick time and family medical leave, and finally, social media. Next slide. So moving first to diversity, equity, inclusion, and belonging, we're seeing an increased focus in this area in the last about 2 years or so. So a lot of times when we do surveys of employees, we find that employees really want to work for an organization that shares their values, and they want to feel like they're proud of their employer. So these issues can become very important in attracting and retaining top talent. We're seeing prospective candidates look at your website, for example, and they want to see that you have a diversity and inclusion statement on that website. And so because of that, now employers are saying, okay, how can we include those statements into our actual policies that we're going to follow on a day-to-day basis? So we're seeing employers start to put those statements in their handbooks directly. A few pointers on this: if you're going to put something like that in a handbook, you want to make sure you're keeping it brief. The handbook is not a place to talk about how you're actually going to operationalize that effort, but it is a good place to make a short statement and emphasize your commitment to that area. Also important, as always, make sure your actions match up to your words. You don't want to overpromise or overcommit or represent that you're doing something that you're not. Employers are at different stages in this effort, and you want to know where you stand in that. You also, because of this, might have to revise your other policies to be consistent with those commitments. For example, you might want to go back and look at your handbook to adopt maybe gender-neutral language to be more representative throughout the handbook, taking out she and he. Dress code, this was a little bit old-fashioned, but we do see handbooks sometimes that have a dress code that still has differences for men versus women. We're seeing a move away from that into more general commentary on what's acceptable to wear at work, regardless of your gender. No need to distinguish anymore. And then, of course, strong discrimination, harassment, and accommodation policies go hand in hand with this area as well. Next slide. Talking about where and how we work. With the pandemic, remote work seems to be here to stay. Employees are really pushing employers to maintain that flexibility. As this relates to handbooks and policies, that means that even though a lot of employers may have had flexible work and remote policies for some time before the pandemic, they're very likely dated at this point. So we recommend looking at them and making sure that they really reflect the current practices and expectations of your organization, because there's a good chance they don't reflect the reality of your workforce in 2021 and now moving forward into 2022. Talking about remote work, there are a ton of wage and hour policies that are going to be implicated by this. So you want to make sure you're taking a close look at those to be sure that employees are aware of them. So for example, looking at work hours and reporting time, when you have employees that are around you in an office, you can generally see when people are working through their lunch or when they're working really late at night. And so if these employees are non-exempt, you need to be paying them for all of that working time. And the only way that you can really ensure that you're compliant with these laws is to make a very clear statement in your handbook about reporting that time and making sure your employees actually read that handbook and know what they're supposed to do. You want to make sure you put the onus on the employee to comply versus you somehow trying to know where your employees are at all times. Meal periods and rest breaks do still apply even if employees are working at home and they're non-exempt. They should be logging off their computer and stepping away for whatever that period of time is that you lay out in your handbook. And then finally, reimbursement of expenses. This is a big area. We've seen some changes to this in the last maybe 5 years or so. Illinois is one of the states that has its own expense reimbursement requirements for employers. It has sort of a de minimis standard to it. We don't recommend that you have a very detailed policy in your handbook per se. You should lay out that you will reimburse for ordinary and necessary expenses that employees have while they are working remotely. So we're seeing, internet and phone use are the two big ones that employers are making sure they are reimbursing for now that you have this workforce that might be working from home a substantial portion of the time. Next slide. Talking about hybrid work policies, related but a little bit different. This is distinguished from flexible work arrangements. So right now we're going to be looking at the move from employers where they might have had in the past a small group of employees who maybe worked at home the whole time or occasionally worked at home to now having potentially the majority of your office working both in and outside the office. So as always, employers need to be very clear about what the expectations are and make sure that everyone is on the same page from the management down. For example, how many days do you want employees to come into the office? And how many days can they be remote? Do you want to do a 3-2, a 2-3, something more flexible than that? And then core hours. So are there certain hours that you're going to expect your employees to be available? And if so, you should state that in the handbook. You want them there from 9 to 5 or 8 to 6, or maybe something more flexible as long as they're getting their work done. So the rules very likely are going to differ depending on if the employee is exempt or non-exempt. But so long as you're communicating what those rules are, you should be all set with that. Responsiveness too, of course. Do you want them to answer their emails within 24 hours by the end of the workday? Letting them know what the expectations are in the handbook is a good way to make sure that everyone is going to be on the same page. And then mode of communication as well. So is it okay for them to just use email? If your company has adopted some sort of an IM system or a texting, do employees have each other's numbers and that's how they're now communicating with each other remotely? We're seeing a lot more of the IM and texting, which can cause a lot of issues for a lot of different reasons, but probably the number one problem with that is just retention. A lot of those, especially the IM systems, don't have the same retention policies that your email might. And so being sure, if you don't want employees communicating about important things that you want to be able to ultimately retain later, you might want to put in your handbook that employees should be communicating via email to the extent possible. Wage and hour implications are, of course, implicated here with hybrid work as well. We've already touched on those on the previous slide. And then finally, you want to just include in the policy that it's subject to change. As you all know, things have been changing fairly rapidly, and it's a very fluid situation. So let the employees know that this may or may not be here to stay, but of course, it's always a good idea to spell out that there might be a notice period, there should be a notice period, so that people can, handle their personal lives accordingly and have time to adjust to the extent that you ultimately maybe don't have a hybrid work policy anymore. Next slide. Okay, this is everyone's favorite, sick time and family medical leave. In the last 5 years, maybe 10 years, we've seen a huge increase in paid sick time on the state level. So right now, there are numerous states that do require this. And so when we as a team are looking at handbooks, this definitely represents probably the bulk of the time that we spend looking at these handbooks is just going through sick time and family medical leave. And what we try to do, and what you should do as well, is try to find a way to make a policy apply to the largest group of people as possible. If you can make that policy apply to 90% of people, with certain exceptions for various states, that's on an administrative level, of course, going to be a lot easier. So right now we have 15 states that have paid sick leave laws, and then a number of other states also have unpaid family medical leave laws that don't match up with the federal family medical leave laws, so you need a separate policy for those as well. We have all these different states, and then on top of that, you also have a lot of different cities that have various requirements. So that's why this can get very complicated if you do have a national group of employees. About a month and a half ago, we really were expecting federal family leave to take center stage, but it's looking like that may not happen anymore. It was a part of the Build Back Better Act, but it's received a decent amount of criticism at this point, given the budget. So if it was ultimately passed, we don't expect it would pass with more than maybe 4 weeks of paid leave. But right now, it's pretty safe to assume that that's not going to be something you're going to have to worry about in 2022. And if you did, it would probably be the latter half of it. Next slide. Family and medical leave laws. So unlike sick leave, it's hard to do a one-size-fits-most for family and medical leave policies that are going to account for every state. And there are a couple of reasons for that. In general, there's just a lot of differences in what the requirements are. So some will let you have a private plan, some have different eligibility criteria, different benefit amounts, different length of time, and different reasons that you can take the time off. So unfortunately, because federal leave probably isn't going to come into play, we're going to continue to see a patchwork, and that's going to play into your policies. So if you're in a jurisdiction with these leave laws, that requires you to look at other policies like accrued vacation, sick days, just to make sure that you're consistent. Next slide. Our final trend, talking about social media. So most employers do have a social media policy, and we're seeing them make clear now more that posts that employees make outside of the workplace could affect employment. So what usually happens here is that you receive complaints from coworkers or maybe even clients or prospective clients. They might Google someone and then find, their Facebook or their Instagram and see something they posted, and maybe it's, inappropriate or sexist or something like that. And you get a report saying, they're no longer comfortable working with this person. So you just want to be sure with these policies that you can address that in some sort of a way. We're seeing now in policies that companies are holding their employees accountable for posts that are made outside of work, that are made on their private accounts, but the most important piece of it is the last piece, that impacts the workplace. So having some sort of a statement like that in your policy is going to go a long way. No one here wants to be the police of whatever employee does on their personal time. No one has the time or the interest in doing that. But to the extent that those issues come into the workplace, you do want to have a strong policy that allows you to address that and to discipline the employee accordingly. And then just one caveat that I'm not going to go deep into just based on the time that we have, but you do want to make sure with these social media policies that you're not affecting employees' rights to engage in concerted activities, which are protected under the NLRA under Section 7. So, of course, we're always happy to help you make sure that you craft the language to make sure that it is narrow, but also as broad as you hopefully want it to be. But there are, certain requirements that we do have to comply with under the NLRA to make sure that employees are allowed to talk about their wages and their working conditions and things like that. Next slide. Okay, this slide is a doozy. I am not going to take you through every single update we have. This chart that you're seeing here is 2021 and 2022 updates. It's not completely inclusive, but we did include the ones that we think are the most important. So some of the things you're seeing on here include changes that came later in 2021 that might not be in effect until 2022, or they're already in effect and we just think that they're important enough for you to make sure that you're aware of. I know we have a largely Midwestern audience here, and so for you all, Illinois has been very active, as usual. We've seen a lot of changes this past year, and some which will go into effect in 2022. So some of those changes that we have seen is the Chicago-Cook County paid sick leave laws were amended to add new reasons for use. We also saw new protected classes added. So you do want to update your EDO policy to be sure that you're inclusive of that. VESA was amended again, amendments in 2021 and then amendments for 2022 that include expanded family member and new documentation requirements and confidentiality requirements. So those are some of the big ones, and then an update to the kin care law as well. So we are always happy to help you with that, and feel free to follow up with any questions you have about those specific laws. But otherwise, I think my time is up, and I'm going to turn it over to Matt, who is going to talk about trends in EEOC-initiated litigation and also equal pay. Thank you.
All right, thank you, Kyla, and good morning, everyone. I'm going to talk very briefly about major developments in EEOC litigation and equal pay litigation. Let's go to the next slide. All right, the big news of 2021, and it's a theme you've heard a couple times already today, is the change in administration, which has resulted in the EEOC in a change in leadership. So the commission's leadership team includes 5 members, including the chair, vice chair, and 3 commissioners. They have to be split 3-2 between Democrats and Republicans, and it just depends who's in office when it comes time to nominate the commissioners. Changes in EEOC leadership have proven to bring real changes to how the EEOC pursues its mission, especially its litigation mission. In the last year of his term, the Trump administration finally got around to filling the commission with 3 new commissioners, and that solidifies a Republican majority through July 2022. And so that's a massive change. But Biden also made changes as soon as he got into office. On the day of his inauguration, in fact, he switched the chairs. And so it had been Chair Janet Dillon prior to that. That was Trump's nominee. And it was changed to Charlotte Burrows under Biden. And so that has a big impact. I think it's a bigger impact when the commission changes hands 3-2 from Republican to Democrat or vice versa, but the change in the chair is also a huge change. And that can be reflected in some of the changes that the former chair, Janet Dillon, made to the commission. And I want to talk about 2 of those in particular. Essentially, through her the statements that she's made, through just looking at the changes, et cetera, it does seem pretty clear that the changes were meant to curtail the EEOC's litigation program and to, put a stop or at least cramp a little bit what many people have seen as the EEOC's sort of shoot first, aim later style of litigation. So 2 changes that she made that are going to continue to reverberate into 2022 at least until there's a change in the commission structure in July. One is that in March of 2020, the EEOC released an internal resolution that dramatically changes how high stakes litigation is pursued by the commission. Essentially what it does, it pulls back litigation authority from the general counsel's office, historically a very, very powerful position within the EEOC, and from the regional attorneys in terms of the types of cases that they pursue and how they pursue those cases and the types of theories that underpin those cases. just very briefly, the types of cases now that have to go straight to the commission instead of being taken directly from the general counsel's office or by regional attorneys are cases that involve systemic discrimination, pattern of practice cases, those that would involve a major expenditure of resources, and then what many people believe, a series of changes that many people believe are probably related to things like the Bostock decision, the LGBT rights decision that came out, I believe it was last year. So those changes are cases that present issues on which the general counsel proposes to take a position that's contrary to precedent in the circuit in which the case will be filed, or where the commission will be taking a position contrary to precedent. And other cases reasonably believed to be appropriate for commission approval in the judgment of the general counsel, including cases that implicate areas of the law that are not settled and cases that are likely to generate public controversy. I think that does seem to be a direct outgrowth from what the EEOC has managed to accomplish in the terms of LGBT rights. Another change I want to mention just briefly is Janet Dillon also tried to make some changes to the EEOC's conciliation process to make it a little bit more pro-employer. She mandated that the EEOC would have to, or through a rulemaking process actually, she tried to push through a rule that would require the EEOC to provide certain information to employers who are engaged in the conciliation process. Turnover in Congress meant that change, although it was passed through the rulemaking process, became effective very briefly. Congress, through the Congressional Review Act, put a stop to it. So this was another change that had been on the horizon, just 6 months ago, now no longer going to be impacting employers going into 2022. There are other changes as well, also very important, but let's go ahead and move on to slide 2. I'm sorry, slide 3 of this. Well, the next slide will show that the yearly filings on a month-to-month basis over the past 4 years. We like to show this information on a month-to-month basis because the EEOC, as you can see, has this odd habit of filing most of its cases at September of each year. That happens to be the last month of its fiscal year. So year after year, we do see this rush to the courthouse in September, except for last year. You can see that blue line was a little bit of a dud. The numbers here, I think, show the impact of the changes in leadership of the EEOC. So this year, the EEOC filed 114 cases. That's a bit up from last year, which is 101 cases, but that's significantly down from 2019, 149 cases, and 2018, 217 cases. So really cutting the number of case filings down in half is what we saw as a direct result of the changes in leadership, which are going to continue to impact EEOC's mission going into 2022, but we expect will be quickly reversed after July of 2022. We'll see. It does take time to nominate and then go through the Senate approval process, but that's a change that we're looking for. And I do think, and I have it, we have it on a pretty good inside authority that we do believe that the number of case filings is going to increase pretty significantly into 2022 and especially beyond. All right, let's go to the next slide. We're going to shift gears here. We'll advance one more. We're going to shift gears to talk about pay equity litigation, another topic near and dear to my heart. I want to talk today that the most significant development, I would say, is the changes that the states have been trying to make to the equal pay laws. I don't know if we can go, let's go to the next slide if we can. There we go. Thank you. Let's keep it there. And those changes, well, generally speaking, equal pay litigation works under a burden shifting mechanism. So under the Equal Pay Act, first an employee must establish a prima facie case. The burden then shifts to the employer to prove one of the 4 enumerated affirmative defenses that are allowed for in the statute. If it can successfully do so, then the burden shifts back to the plaintiff, who must then try to show that the employer's reasons for justifying the pay disparity are merely a pretext for discrimination. And so the previous slide showed us the elements of a prima facie case. what the states have been doing, and one of those states is Illinois. California was the leader a few years ago. Illinois followed suit a few years later, and it's been on the books for a little while, but we have not had a significant case decision until this year showing us how those changes might impact equal pay litigation. Let's talk about them briefly. With respect to the prima facie case, one of the things that an employee has to show is under the Equal Pay Act that that person was performing equal work compared to a comparator employee, but were paid less. And what the states have done is to, in some people's opinion, to try to water that down. Not equal work, but substantially similar work is the new standard. Here we can see then the burden then shifts to the employer to try to establish one of its affirmative defenses. The most important affirmative defense by far is this any other factor other than sex defense. It's kind of a catch-all, and even if there's a seniority system, a merit system, something else involved, typically it all gets shunted into that any other factor other than sex requirement. What the states have done is they have enacted changes to that any other factor other than sex affirmative defense to make it, many people see or think, more difficult for employers to establish that. And the way they've done that is to require that the any other factor must be job related and consistent with business necessity. It also cannot be based on a historical pay discrepancy, which a lot of people think will eliminate the use of prior salary history, another huge development in equal pay litigation over the last few years. So they're trying to, the states are trying to disallow the use of prior salary history, and Illinois is definitely one of those, and also to curtail that factor other than sex defense so that it must be job related and consistent with business necessity. All right, let's go to the next slide. All right, now let's talk about what that significant case that I mentioned earlier is. That's the Ellis v. Google case in California. This slide shows you the different procedural mechanisms that are available to equal pay plaintiffs, whether they proceed under the Equal Pay Act, which is a collective action procedure, versus a class action. The state laws are class action procedures, and there was a push to try to change the Federal Equal Pay Act to also involve class action procedures, but that has gone nowhere so far. The Ellis v. Google case is interesting because it ties together many of the changes that I've been talking about and many of the changes we all have been talking about for the last 5 years or so that have been enacted by the states. So in the Ellis v. Google case, a class, the court recently certified a class of over 10,000 women who work at Google's headquarters in California on allegations that they're paid less than men on a systemic basis. What are the takeaways from this decision? One, that job codes, okay, so Google had classified its employees according to certain job codes, were sufficient to establish that some would say reduced standard of the substantially similar work standard to establish a prima facie case. That was satisfied by just showing that employees worked in different or shared the same job code. And that allowed the plaintiffs to hold together a class that includes women in positions all up and down the chain, you know, from very high level positions to lower level positions. You can compare people across job codes. Next, pretty, I thought, inventive of defense counsel here. The defendants tried to rely on the changes to the factor other than sex affirmative defense to show that this heightened business necessity requirement would require them to look on an individual by individual basis to establish that affirmative defense. And the key takeaway from the Google case is that the court did not buy that and said that the factor other than sex affirmative defense can still be established on a class-wide basis through class-wide mechanisms of proof, which essentially takes out a major arrow out of the quiver for defense counsel in these types of cases. And then finally, final takeaway, although the Google case had been premised on a theory that their use of prior salary history to set starting salary is what gave rise to that salary discrepancy that they're complaining of. That was considered to be the glue for years, the glue that was going to hold that class together. In the end of the day, it did not. It did not factor in a major part into the court's decision. It did factor in into the disparate impact part of the decision, but not into the primary focus of that decision, which was sort of that state level Equal Pay Act part of the decision. So that was a big surprise. The Google case, I think, far and away is the most important development in equal pay litigation, because it is the first time we've seen, or at least in my opinion, the first major development we've seen that shows how courts are going to start to interpret these changes in state law, including here in Illinois. All right, thank you. I will now turn it over to Amina and Jen to talk about ESG trends in human capital.
But before we do that, hold on, ladies. Hold on one second. For those of you who are looking for CLE credit in the presentation today, let me read that code out to you. Get your pens and papers ready, ladies and gentlemen. It's SS, so Seyfarth Shaw, SS 6329. One more time, SS Seyfarth Shaw 6329. We're going to turn it over now to Amina and Jen. Please continue to put in your questions into the chat function. We will read, we've gotten a couple of questions. We will definitely get to those at the end so that everybody knows what everybody's thinking. Ladies, over to you. Thank you.
Thanks, Erin. Hi, everyone. I'm Amina Majid. I co-chair our ESG Corporate Citizenship and Human Rights Group, and I'm with one of our group's team members, Jennifer Kraft. So far, we've shared trends on a number of distinct issues or subjects that are really elements of human capital, different matters that influence the stability of the organization, but more from that regulatory and litigation lens. So ideally, they roll up into a strategy for the management of talent. Jennifer and I are going to cover how human capital topics are having heightened prominence through the lens of ESG, or environmental, social, and governance. We're going to share what we see in terms of disclosure of human capital metrics, the influence of shareholder proposals on disclosures, and on using incentives to advance human capital management goals and strategies. But first, I want to start with a little bit of level setting. So next slide, please. ESG is literally everywhere, and it's coming from a lot of directions with different expectations on what to disclose. I don't know. And then there we go. And what we show here are macro level pressure points that are really contributing to the amorphousness of ESG. The space is not regulatory led yet, but it is on the path of being so. And needless to say, it's pretty easy to get overwhelmed. To dial it in though, ESG really starts as an enterprise value conversation that's being shaped and driven by investors. So kind of to go back a little bit, or big picture, you know, when you look at where the value or how your private equity or investors in the marketplace are valuing its organizations, is between tangible and intangible assets. And intangible assets, those are your brand, your goodwill, your talent, human capital, and that nowadays makes up about 70% of an enterprise's value. And that's what's behind a lot of the investor focus. So, and that's it's pretty apparent here on the slide. So Jen will elaborate a little bit on the SEC, but under Gary Gensler's helm, there's an enormous focus on ESG disclosures because of the investor and what's material to investors. The major asset managers like BlackRock, State Street, and others, and even private equity, they make the case that ESG is a value proposition. So there's a very heightened focus on human capital in particular. And companies in the public space are also being rated and ranked. So as we help clients kind of navigate through the space, there is a lot of noise, and the way we do it is to really hone in on something Kyla said, which is there needs to be really an alignment of values, your commitments, and your actions. You know, not every topic under ESG is going to be of the utmost importance to an organization, so it does require some priority. So ultimately, though, all of these pressure points are pushing for disclosure. Next slide, please. Disclosure, though, is really just an output. It's a reflection of an ESG strategy. You'll hear that more and more nowadays. And it's also an execution of that strategy consistent with the organization's values and purpose. ESG is often talked about as if it's a whole separate area or even sometimes as an area of law, but it's not. And when you look at the slide, so many of these topics are topics unto themselves. And you might think, well, I'm a labor lawyer or I'm an employment lawyer. I don't really get into board governance or I don't really get into exec comp. But a lot of these issues are very interwoven and they're not always apparent at first blush. So, for example, it's increasingly difficult to think of climate impacts as separate from impacts to human rights. Or the language around DE&I and human rights is also starting to shift. So DE&I is language that kind of indicates an inward focus and human rights a supply chain focus. But that is even kind of breaking down that distinction. So what we offer here, instead of kind of thinking about ESG as a separate area, or separate vertical even, at a macro level, we organize it by putting governance at the top. The board, back to the investor focus, is accountable to shareholders. They're expected to have oversight of ESG. When we talk to clients, a lot of asks are coming from the board. So just like on corporate strategy and oversight of traditional corporate matters, there needs to be that healthy and open dynamic with management. And that's really very, very critical. So to just kind of wrap this foundation up on the next slide, the other thing we talk about is when you look at human capital, there's a lot of different pieces to it, but it, like I said, it ideally rolls up to a strategy. But you know, the way we think about where ESG fits in the larger organization, we're always going to start fundamentally with corporate strategy. That's the foundation. That's where, you know, you figure out how the organization makes money, your products, your services, your competitors, how you differentiate them, and that's what drives long-term value. Layered on top of that and integrated with it is ESG, you know, the strategy around your human capital to achieve that corporate strategy to foster that long-term performance. And what we are finding is the organizational silos, they're getting broken down. And similarly, the role of counsel is changing in terms of how they are starting to advise business. So with that, I will turn to Jennifer to share, to start sharing how the role of counsel is changing.
Yeah, thanks, Amina. And on the next slide, we get into this a little bit more. There's a few new risks on this landscape. Like Amina said, ESG is every place. And with that comes a few new legal risks and business risks as well. There are new federal securities laws exposure for if we have materially misleading or false statements in public reports, that could cause exposure, state corporate breach of fiduciary duty provisions that could come into play, as well as business risks related to brand and reputational risks that can come into play as well. So because of all these new risks there, and because ESG is everywhere, there is a lot of buzz about ESG, and you may already be hearing it in your organization. So the question is, what does that mean for you? If you work in the human resources space, if you're in-house labor and employment counsel, that means that this area that you are working in, day out, is now becoming a very big deal for a lot of other reasons as well. So there might be a lot more scrutiny under your area. And what that's going to mean is really, number one, you know, having a little bit of the context of this ESG discussion that Amina just kind of laid out is very helpful. So you have kind of the big picture strategy. I think there can be this immediate reactionary type of approach of, okay, I've heard ESG and we need to do something and get something out there. And thinking through kind of from a big picture level, what's the corporate strategy and how does ESG layer on, will help kind of guide that discussion and guide the new focus that may be in the human capital area in your organization. What that will also potentially mean is that there's going to be some kind of translating between the general day-to-day business and then up to corporate counsel or the board if there's this interest and renewed focus on ESG and human capital matters. So it'll be incumbent on the in-house labor and employment attorney to really be able to translate, or HR executive to be able to translate those business needs and what we're doing on the ground and report up to the board so that they kind of understand what's happening, and now you guys have a little bit more context of why they may be as concerned about this. The next slide gets into, as Amina alluded to, there are these new SEC regulations for public companies, and this is a public company regulation, but because many companies are public and we're seeing that, I think what happens there may sprinkle over and guide into non-public companies as well, so it's helpful information. These new SEC requirements went into effect last year, for last year's reporting season, related to human capital management, and it was a very broad-based type of approach. It was basically, you know, the bullets here, the 2 bullets under the new SEC requirements are basically what the new disclosure requirement said, that you're basically supposed to describe your human capital resources and measures and objectives, and then talk about, you know, your human capital measurements and measures or objectives. And, you know, they said, for example, development, attraction, retention of personnel. So this first go round, the SEC has elevated this to an issue that they want to be reported, but it went with more of a principles-based approach rather than prescriptive. There was no requirement that you have to report this metric or you must report on that percentage. It was really just, what does the company think that their investors will find material related to their human capital management processes. And so with that, you know, it was a very interesting type of approach. I think the first year of disclosures was really all over the board as far as what various companies were reporting in this metric. And part of it was because I think some may have already had those types of metrics and reporting that they were disclosing for other purposes, so it was easy to incorporate those into the SEC filing. Others may have been taking more of a wait-and-see approach with less is more until we see kind of what the scope of these types of disclosures are going to be going forward. We in the ESG group were really interested about how these were going to look. So if you can flip to the next slide quickly, and then we'll come back. We actually analyzed over 100 of these human capital management disclosures in these SEC filings across industries to start to get a sense of what types of things they were reporting, what trends we could see, and how they might vary. And this chart is an excerpt from our human capital management report that we issued earlier this year and is available. We'll send information to you about how to get this report after this presentation. But what this report, what we're able to see is kind of some trends that kind of went across the board, as well as with industry specific. So last year being the first year that it went into place, and it was COVID, there was a lot of emphasis on safety. So these bubbles kind of reflect, they're categorized by industry, and then the number of, the percentage of those reports, or those disclosures that we reviewed that mentioned some of these topics. We kind of looked through and said, yep, they mentioned COVID, yep, they mentioned culture, demographics, D&I, et cetera. And what we saw kind of across industry is that COVID was a very common theme, a lot of focus on workplace safety related to COVID. And as the chart here shows, diversity and inclusion was a very consistent theme throughout industries and on most of the disclosures we saw. What was interesting is there was a lot of variance as to what topics and how much detail was provided in that diversity and inclusion disclosure. So for some, we saw some metrics where the companies were reporting the metrics of their demographics of their workforce. For some, and even with those that did provide metrics, that varied as well. Some kind of broke it down by race and had different ethnic and racial categories. Some kind of lumped all people of color or underrepresented groups together. There was some that provided metrics on gender. Some provided metrics on age and generational. You know, there's an issue with baby boomer retirements and We see that in our benefits practice as well, where companies are struggling to deal with. We have a lot of folks retiring, and how are we transferring that knowledge, and what is our leadership, our transition succession planning as well. And then some included promotion metrics about how folks were being promoted. And as I mentioned, we did do, if we can go back to the other slide, the previous slide, please. The report itself provides more detail on each of these, as well as insights related to various industries. And I think what we'll see in the year ahead is now we have kind of a benchmark. So as people are preparing their disclosures, or companies are preparing their disclosures for this year, we'll be able to kind of benchmark against their industry and see what sort of things were being reported elsewhere. Because this is the first year, those disclosure standards are going to evolve, and as Amina alluded to, the SEC Chair Gensler is very interested in this area in particular. In fact, in mid-September, he was testifying before a Senate committee and noted that human capital management was very important to determining the value of a company. And when he previously worked at Goldman Sachs, and he noted that that was really important as he was evaluating companies. That's something that he looked at. So because of that and kind of other trends, as Amina noted, we're expecting to get a little bit more requirements around what those disclosures are going to need to look like, which all of this is to say that there will be continue to be focused on this area, and those disclosures and what you need to report may evolve as things go on. And the last thing to note there, as I mentioned at the beginning, is even if you're not with a public company, the fact that many companies are looking at this in this area, and even non-public companies may have ESG or sustainability reports, there are going to be, we've been seeing a trend for customers asking for this information as well. So being aware of this and how your company is going to respond is going to be helpful for a number of reasons. So if we can go 2 slides ahead, we'll talk a little bit about kind of, all right, well, where do we go from here? I think that the thing to think about here is a lot of what Amina was talking about before, is thinking about what your strategy is from a human capital management, and where we are now, where we want to go, and what are some of the metrics that we might look to kind of help establish that goal. One of the things we noticed in the human capital management disclosures from last year is that to the extent companies did include metrics, they were all positive or frame them in a positive light, which is great, and I think is our natural reaction to try and put things positively. But as these disclosures continue on, what investors may be looking for, what may be more important, is growth. It's not kind of a one static snapshot. It's kind of how are we evolving as a business, and how are we improving. And so detailing some of those metrics and thinking about what type of metrics might make sense to track there would be part of this, and benchmarking against others in your industry as well. I will move on to the next slide and turn it back to Amina, because this roadmap piece, it's an evolving process, and there's going to be lots to think about as we move forward.
Yeah. Thanks, Jen. So another avenue being used for disclosure are shareholder proposals. So again, it sounds like we're kind of in that public company space still, but they're, again, instructive, and they're just that other force. But it's interesting because, the SEC, again, is looking at ways to, just assert the importance they're putting on these topics. So what we are seeing here is that a shareholder proposal, by the way, it's submitted. It's a request for companies to make certain disclosures. And right now we're seeing an increase on different human capital topics because, again, the board of directors has oversight and they're accountable to shareholders, which is the heart of ESG. And those proposals are typically 500-word resolutions, and they cite that economic reason. So it's that other vantage that these topics need to be looked at. So the shareholders tend to cite studies from McKinsey or other financial institutions that key certain gender and ethnic representation to EBIT, or shareholder return. Or they might look at how a company is against their peers. So the aim, of course, is to improve disclosure so that investors can evaluate their investment. So we are seeing them increase. The topics that we're seeing are focusing, what's pay equity, it's focusing on median pay in many regards, and the DE&I requests are focused on many things you might expect. So board and executive diversity, disclosure of EEO1 reports, reporting and racial equity audits, and then the statistics that are key are not just the gender representation or how your workforce looks, but are on the retention, promotion, and recruitment, because those are being identified as effectiveness of any program. So next slide, please. We'll just touch on this one briefly, just to give you a lay of the land of how the shareholder process works. You know, just some basics, a little 101, because it does start with an engagement process. So each shareholder and asset manager, they have a process for deciding who and how to engage with a company they invest in. And companies likewise, your investor relations department, they have their process for how to engage. And that's a very closed door process. But there's a large swath of shareholders that submit proposals, from the large institutional ones and the pension funds, faith-based, and now we've got many more investor advocacy groups. So many companies may be seeing proposals from an organization called As You Sow. And companies don't always engage back. If that engagement is unsuccessful, then it gets escalated to a shareholder proposal. And that's where that comes in. And at that point, the company's got two choices. They can maybe work with the shareholder a little bit if they think that's worthwhile of their time, or they can go to the SEC and say, you know what, we don't want to submit this to shareholders, and we want you to give us a no action letter that you won't enforce us if we don't put it on the ballot. And there's been typically reasons that the SEC will allow those shareholders to be, proposals to be excluded. You know, things like the proposals micromanaging the company. They are not appropriate for shareholder oversight, or there isn't an economic relevance. What's key now is, again, the SEC is saying, it came out with an interpretive bulletin saying, we're going to shift from looking at a company-specific approach to evaluating the shareholder proposals and really focus on social policy significance of the issue. So this relates back to what Kyla had said about social and political issues really influencing policies and procedures, because social norms tend to affect business norms. And now we're seeing that in regulations from all sides. So we can expect more of these shareholder proposals to go on the ballot. If a shareholder proposal receives a majority vote, they are non-binding. So directors aren't at risk for risk of a fiduciary breach for not acting on the vote. But what happens then, it puts their election at risk, because we do have many more institutional investors saying, well, okay, you know, you don't want to give us this information or whatever, we're going to start a campaign, and maybe, you know, you may not be having oversight of the organization. So the takeaway is to try to look at human capital through this ESG lens and how it may impact strategies at that economic lens, and also the board, and take into account the board oversight and the board role. And I will let Jennifer talk about one of those governance mechanisms, which is exec comp, as we wrap up.
That's right. As the next slide indicates, because of this, all of this focus on ESG and how, particularly in the U.S., there's been a lot of focus on the S, the social aspect of ESG. We have seen that come into executive compensation plans as well. And part of that is because, you know, that's diversity, equity, and inclusion is an area that we've been seeing a trend in, and that HR and human capital teams have been looking at for some time. So thinking about how to incorporate that into an executive compensation structure comes in with a lot of options and variables that can be done a number of different ways. Kind of what metrics are we going to look at? Are we going to look at operational ESG metrics or sustainability ESG metrics? Are we going to look annually? Is it going to be more of a long-term goal? Will there be some component of both? Is there going to be a formula? Are we going to look at these metrics, and if they move in the right direction in the set number of times? Is it going to be a formulaic distribution or bonus, or is it some type of discretionary bonus? Again, as with everything we've been talking about here, all of it is going to come back to the company strategy and what makes sense. It's not going to be a one-size-fits-all approach, and you're going to, it would need to really be focused on the company at issue and what's going to be best there. If we go to the next slide, that's exactly what we're seeing in the marketplace. So just so you don't think like, oh my gosh, we don't do this. Is everybody else doing this already? The answer is no, not everybody is not doing this yet, but we think there's probably a trend this way. But we did this chart is very interesting because it took the top 200 companies in the S&P 500 and then the bottom 300. So it wasn't just, we're only going to look at big companies. We're going to look at the top of the biggest companies and then the smallest companies that are still on the S&P 500, and look at what types of metrics are coming into play for their executive compensation programs. And as you can see here, you know, what we've been talking about, again, diversity and inclusion and talent development and even turnover and retention, those are all really high on the list of those companies that are providing some type of ESG metric. Those are the ones that we're seeing the most. So again, this is an area that is evolving. The next slide gets into some things to think about as you design, if you're going to design an exec comp program that includes an ESG metric, looking at the strategic priorities, determining what your gaps may be and how to measure them, and then prioritizing the business's goals. I think in general, I'd say it may be kind of premature to include that if you don't have those type of metrics all in place as well, but it may be part of the discussion as you're thinking about human capital strategy in general and what types of metrics to include. Executive compensation may become a piece of that. So I am going to turn it back to Erin to answer some questions, but thanks so much for the time today.
Thank you all. Thank you, presenters. You guys have been great. Always fun to have listening to my amazing colleagues and how brilliant you all sound. So thank you for that. For those of you still listening, we will be sending out a copy of the audio, a copy of the slides, and then you will be getting that a little bit later this afternoon along with your CLE form. Recognizing we're 3 minutes before the hour, so I just wanted to go back to one of the questions that we had. Kyla, you were asked a question during the chat, if an employee requests to work remotely, do internet upgrades need to be reimbursed? Can you just address that quickly, specific to Illinois here? So
yeah, no problem. So I had mentioned expense reimbursement laws definitely depend based on the state that you're located in. Illinois has one of the stricter laws, I would say. Illinois and California are fairly strict, but with that being said, the expense still has to be necessary, is the language of the statute, and it has to be within the scope of their employment. So one of the questions we got was, do you have to reimburse an employee for an internet upgrade? So internet's one thing, but having the employee ask you for an actual upgrade to a faster speed internet, unless there's something unique about that employee's job that makes that faster internet arguably necessary for them to complete their job, I think it's safe to say no. You don't need to reimburse them for that. But with that being said, a lot of employers are reimbursing their employees for internet. Just a note on the Illinois statute, like I had said, it's a de minimis standard, which you can take that a lot of different ways. No, you can't reimburse them $1 for their internet, but you don't have to reimburse it 100%, so long as your policy is specific on what the employee needs to do in order to get that expense reimbursed, and then also what percentage of that you're going to reimburse them for. We've seen is definitely in the 50% range has been definitely been fine. Even something maybe in the 40 or 30% would be okay, so long as it's not in the 20 to 10% range. You should be safe, but going above and beyond is not going to be necessary even in a state like Illinois in terms of internet usage.
Thank you, Kyla. With that, I'm going to say thank you all very much to once again to our speakers, to the presenters, and wish everyone in the audience a very happy holiday season. We look forward to seeing you physically live and in person in Q1 next year. Let's keep our fingers crossed. Have a great day, everyone, and thank you again. Take care.